Good morning. I'm Ruthi Rajan, Deputy Editor of The Oath Legal Magazine. Thank you for joining the Oath GC Talk webinar series. This morning, our webinar is in association with the law firm Galadari Advocates and Legal Consultants and legal research partner LexisNexis. The topic we're covering this morning is arbitration in the Middle East, enforcement and challenges to arbitral awards. The session will focus on the mechanisms available for recognition, enforcement, and challenges to arbitral awards in the Middle Eastern jurisdictions of the UAE, Saudi Arabia, and Egypt in a comparative analysis format. The discussion will highlight practical aspects for practitioners and parties to keep in mind while seeking to recognize, enforce, and challenge arbitral awards. Our speakers, Fadi is partner and head of Galadari's Abu Dhabi office. He is a qualified lawyer with over 20 years of work experience in Lebanon and the UAE. Fadi specializes in corporate and commercial matters, litigation and dispute resolution, with a focus on a variety of practice areas. Sergey is Senior Associate at the Dispute Resolution Department of the firm's Dubai office. He has over 13 years of experience in advising and representing multinational companies and high net worth individuals in a wide range of complex institutional and ad hoc arbitration proceedings. Fadi and Sergey will lead the session for the first half, and this will be followed by a Q&A session. There is an option on the right side of your panel on both the laptop and the phone to type and send in your queries. As it is a session that is scheduled for an hour, we request you to send in queries that are relevant to our discussion today. Over to you, Fadi and Sergey.
Thank you, Ruthi. Good morning, everyone. This is Sergey Dilevka. I am a Senior Associate at Galadari Advocates and Legal Consultants here in Dubai. And joining me today is Fadi Hassoun, Managing Partner of our Abu Dhabi office. I will be making a few introductory remarks in the third session of today's presentation, followed by Fadi Hassoun, who will be speaking on recognition and enforcement of arbitral awards, and I will be concluding with challenges to arbitral awards, and perhaps we will be also answering your questions. So this is today's plan. Going quickly into the introduction. In 2008, Queen Mary College, University of London, and PricewaterhouseCoopers, a consulting firm, a global consulting firm, conducted a study and found that 84% of respondents advised that in more than 76% of cases, compliance with arbitral awards, and a little caveat that these were investment arbitral awards, was voluntary. Fast forward around 13 years to today, anecdotal evidence and our experience suggests that overall compliance or voluntary compliance with the decision in arbitral awards has been decreasing. And we would like to speak to you today on what are we going to do in this case. So the stage of the arbitration is now the second phase, which is the enforcement of the arbitral award. So the award is out, your debtor still refuses to pay. Now what? What are your options? The first thing to recognize, we suggest, is that it's not a runaway train where you absolutely have to go and commence enforcement proceedings. There are options. One option is, of course, which rarely comes to mind, is to do nothing. Perhaps it was all in vain and it just doesn't make financial sense to continue. Of course, there's options. The first option which you should consider is try to negotiate with your debtor, which means that you might settle for a smaller sum, or you might settle for a sum paid in installments over a certain period of time, but that's arguably may be a better option than to commence enforcement proceedings without a clear view of what's going to happen 6-12 months down the line, whether you're going to be able to recover anything. Name and shame is also an option, and it's sometimes used by firms and companies which have, for example, mandatory requirements to inform their shareholders, perhaps in a public joint stock company, on what has happened to a particular dispute. Sometimes you have regulatory requirements where you have to publish certain information pertaining to your obligations and funds which are owed to you. The third option is to sell your awards at a discount, certainly, to a professional recovery firm. There are firms out there which perform tasks which are similar to factoring, which is where you sell your invoices to another company that will do all the chasing on its own, but they buy these invoices from you at a discount. So you can sell your award at a discount to them as well. Of course, another way of pressuring your debtor to comply with the award is to start seeking freezing injunctions on the respondent company, perhaps on individual and their assets. At some stage, of course, perhaps the circumstances are right for you to simply commence for enforcement proceedings. At this stage, one thing to definitely ask yourself, as probably one of the first questions, is, does it make sense to perform this activity, and does it make primarily financial sense to do it? Because we must realize that the enforcement proceedings are not cheap, and time-wise they also do take time. Some of the early considerations which must be had and are rarely, in my experience, are considered is certain questions with regards to your debtors. Do they actually exist, or do they exist now that you're trying to enforce? Maybe they're in bankruptcy or they're in insolvency. Where are the assets of that respondent kept? In what jurisdictions? Are they actually valuable? Is there a mortgage on those? So all of these questions you need to ask yourself as early as possible, perhaps even arguably at the stage of drafting the arbitration agreement, which will require you to consider what is the best seat or legal place that you will insert in that arbitration agreement. And of course, one of the important questions for enforcement of foreign arbitral awards or enforcing your arbitral award in another jurisdiction is, does the Convention on the Recognition and Enforcement of Foreign Arbitral Awards 1958 apply to that jurisdiction? Is it adopted by that country? This convention is known as the New York Convention, which is the place where it was concluded at the UN. Ensuring enforceability, again, is of absolutely crucial, and failure to comply will be fatal to your award. This means that during the arbitration proceedings, you should be already thinking that your absolute goal at that stage is to make sure that the award is complying with all the mandatory formalities with respect to its form or notice. For example, with regards to notice, just ensure that in the beginning of the arbitration, the respondent was properly notified of the proceedings, and that they continue to be notified of milestone developments in the proceedings, and of course at the end that they are notified of the arbitral award, because at that stage in time, this is where the relevant time period for example, for a challenge, starts ticking. Have they participated in the arbitration? Have you done everything you possibly can to make sure that they participate in that arbitration? Is your award in the required form? For example, the requirements, the standard requirements are that the award is in writing, it is signed by the majority of arbitrators, if impossible to have it signed by all of the arbitrators. Has your arbitration been conducted in a timely manner and within the prescribed period? So, for example, under the UAE arbitration law, you have 6 months to conduct your arbitration by default. And if not, then the tribunal, the court, or the agreement of the parties, that arbitration has to be extended. Again, failure to comply with any of those formalities might be fatal. The great thing about international arbitration is that it's still going through the process of harmonization, which hasn't really stopped despite the regionalization of international treaties. So the two most important instruments with respect to arbitral awards, arguably, in the world are the Convention on Recognition of Enforcement of Foreign Arbitral Awards, 1958, the New York Convention, and the Ancestral Model Law on International Commercial Arbitration, 1985, which was also amended in 2006. This is not an international convention. This is a model law, which is the state-of-the-art template adopted by more than 100 jurisdictions, recognizing that this is the best document, the best law which might be used by a country in order to demonstrate, for example, that the country is pro-arbitration, is an arbitration-friendly jurisdiction. And unsurprisingly, this harmonization effort resulted in many of the sentences and provisions in those two documents being quite similar. For example, Article 34 of the model law is close to identical to Article 5 of the New York Convention with respect to grounds to challenge and set aside of an arbitral award, which are visible now on your screen. So there's 6 grounds which are nearly identical. For the purposes of this presentation, they are copy-pasted. Apart from one ground for Article 5 of the New York Convention, and even that ground, the operative chapeau of Article 5 requires or prescribes that the arbitral award may not be enforced if any of these grounds are in existence. So quite a lot of discretion is left with the country enforcing the arbitral award. With respect to the jurisdictions that we're looking at right now, Egypt, Saudi Arabia, and the UAE, these are the arbitration laws for each jurisdiction. So Egypt has its law from 94. Saudi Arabia has, in effect, an arbitration law which came into effect in 2012, followed by Saudi Arabia enforcement law, which came into effect actually in 2013 with executive regulations, which prescribe the methods and what needs to be done with respect to enforcement of an arbitral award. Thankfully, again, these countries do demonstrate over the last decade or so that they are a pro-arbitration friendly jurisdiction. They are all based on the model law, what's in in our profession called inspired by the model law. And at the same time, they have been parties to the New York Convention for different periods of time. Egypt since 59, Saudi Arabia since 94, and the UAE became a party in 2006. And of course, apart from the New York Convention, there are other treaties that one can consider within this region, within the Middle East, with respect to trying to enforce their arbitral award in another country. But one thing to notice here is that some of these conventions are specific to investments. So unless your award is an investment treaty award, then you might not have the opportunity to have recourse to this convention. And another thing to note with respect to the Exit Convention is that it is agreed between the contracting parties to this convention within the text of the treaty, of course, that awards issued by exit tribunals effectively have the force of a judgment in the country which is a contracting party to that convention. So sometimes countries will or parties will start the proceedings in arbitration under exit rules in order to ensure that at the outcome vis-a-vis the state will be that that award will be effectively automatically enforced in that state, respondent state. Now I will be handing over you to Fadi Hassoun to talk about recognition and enforcing, recognizing and enforcing of arbitral awards. Fadi, over to you.
Thank you, Sergey, for the introduction, and good morning, everyone. Thank you for attending this webinar. I hope it will be informative and beneficial for every one of us. And I hope also that you are safe in these unprecedented times. Recognizing and enforcing arbitral awards. When an arbitral award is issued, it has no effect unless we start initiating enforcement and recognition procedures or mechanisms. An arbitral award without enforcement, it requires to be put in force and granted a binding effect between the parties. We may need to have it recognized and might also be enforced. Thus, we shall go through a short insight during this webinar on what the term recognition means and what is the enforcement and what difference is between enforcement and recognition. The terms recognition and enforcement tend to be interchangeable or always set together. Yet there is a nuance between both terms, and they don't mean the same. When a court recognizes an award, it acknowledges that the award is valid and binding, and thereby it gives it an effect similar to that of a court judgment. So it becomes final between the parties. A recognized award can be relied upon as a set-off in this case, or defense in relation in any related litigation or arbitration to the initial dispute. The award, once recognized, it has an official status and it becomes binding, so that issues determined by the award usually cannot be reviewed, relitigated, or re-arbitrated. While enforcement, on the other hand, it means whatever official means that are available in the enforcing jurisdiction to collect the amount owed or to otherwise carry out any mandate provided in the award. In many instances, the losing party will voluntarily comply with an arbitration award so that enforcement proceedings will not be necessary. If, on the other hand, the prevailing party is required to initiate judicial enforcement because of the recalcitrance of the losing party, then the award will have, in this case, to be enforced. When an award has provided that the respondent is liable to the claimant for money damages, and the respondent appears in no hurry to pay the amount awarded, then the claimant, who is in this case the award creditor, may seek the recognition and the enforcement of his award against the respondent, which is the award debtor in this case. And he may also enforce as per what the jurisdiction is giving him as instruments for enforcement. He can enforce where the assets of his respondent are located. The award becomes final and binding when it comes to its effects towards both parties in disputes. In other terms, recognition in general is a primordial step towards enforcement. An enforceable award is necessarily a recognized one. However, an enforceable award, while necessary, is a recognized one. Recognizing an award could not also lead necessarily to enforcement, as such enforcement might require additional proceedings and further steps to be taken. Moving forward now to the importance of the seat of the arbitration. We're giving an example, as you can see on the slide. This is an example of arbitration agreement, arbitration clause, that says all disputes arising out or in connection with this contract shall be referred to and finally determined under the arbitration rules of Saudi Center for Commercial Arbitration. The seat of the arbitration shall be in Dubai, while the hearings shall be held in Cairo. As you can see, arbitration rules need the sanction of law if they are to be effective. And in this context, the law of the relevant, the relevant law is the law of the seat of the arbitration, or what we call the lex arbitri, or also it's known as curial law. The parties may choose a particular place of arbitration precisely because its lex arbitri is one which they find convenient. Decision on the arbitration seat or the legal place, because it determines the applicable law on the procedures, is of major importance. The place of arbitration constitutes the law of that place governing the arbitral proceedings and the supervising courts. If that law contains provisions that are mandatory so far as arbitrations are concerned, those provisions must be obeyed. And failure to abide, as Sergey just mentioned, failure to abide by those mandatory provisions is likely to result in various challenges during the arbitration, or to set aside and annulment application against the rendered award. Lex arbitri helps to ensure that the arbitral process works as it should. The necessity for such support and control of the arbitral process is, for example, reflected in the unicitral model law, which allows for certain functions and for certain sanctions when the former requirements are not respected to be exercised by the courts of the place of arbitration. Although the choice of a seat also indicates a geographical place for the arbitration, this does not mean that the parties have limited themselves in that place. As it shows in our example on the slide, that it may often be convenient to hold meetings or hearings in other countries, or even remotely, which is now becoming a trend after the spread of COVID-19. This change does not mean that the seat of the arbitration changes or multiplies with each change of the country. The legal place of the arbitration remains fixed and remains the same, even if the physical or virtual places change from time to time. So, as you can see in looking at the example on the slide, although the seat of the arbitration is in Dubai, the hearings, as agreed by the parties, are to be held in Cairo, while the arbitration center that was chosen indicates the KSA. So, Also, in international construction disputes, it's sometimes necessary for an arbitral tribunal sitting in one country to visit the site or to visit the site of the project in another country to carry out an inspection. And here we need to highlight a very crucial and important point that we shouldn't confuse. We shouldn't, that there is a big difference between the law of the seat, which is the applicable procedural law, and the applicable substantive law, which is the governing law of the contract, as it could be also the governing law could be also a different law, totally different than the law of the seat or the lex arbitri. Now, in order to safeguard or to make sure that our arbitral award is valid and is not going to be jeopardized, its validity is not going to be jeopardized, there are some formal requirements that should be respected and that should be complied with. Each of the model jurisdictions we have selected for the means of our presentation today, which are KSA, UAE, and Cairo, have been inspired by the same model law while promulgating their internal laws related to arbitration. So the model law or the unicitral inspired the three jurisdictions for the formation of their arbitration laws, and they adopted it as a state-of-art basis for their national laws related to arbitration, which led to a certain harmonization of the arbitration laws in the jurisdiction that adopted it. Such model law has imposed formal requirements to be respected in the arbitral award that are paramount not to compromise the validity, as I just mentioned. I'm going to go through the basic ones in each of the jurisdiction as fast as I can, only because of the concern of time. Article 43 in Egypt of the Egyptian Arbitration Act set forth a limited list of requirements applicable to the form of an arbitral award, of which violation results in annulment of the award. According to the Article 43, an award must be in writing first. In fact, during the enforcement phase, an arbitral award has to be deposited before the registry to obtain the exequatur of it. So the word or the term deposited imposes or requires the having something physical in writing. So it transpires from such provision that the award has to be in writing. Additionally, the date of issuance of the award and the place of issuance of the award, they must be indicated also in the award. According to the Court of Appeal, failure to indicate of Cairo, failing to indicate the place of issuance results in annulment of the award. Moreover, the Article 43 of the EAA states that an arbitral award must include the names of the parties and the details of the parties and the arbitrators. So it has to indicate the name, addresses, and names of addresses and positions and nationalities of the arbitrators. Failing to do so also would be jeopardizing validity of the award. Additionally, a summary of the parties' claims, statements, and exhibits must be included in the award. And the award, mainly or most importantly, it has to be signed. Ideally, the signature of each member of the arbitration tribunal is required on each page of the award. Signing the last page, in general, is not sufficient. However, it may only suffice if the operative part of the judgment is connected to the reasons. So if a party can establish that the signature or the signatures provided on the last page only is necessarily related to the lack of deliberation, in this case, the award may be subject to nullification. An arbitral award can be validly issued with the signatures of the majority of the panel members. In this case, the reason for omitting or for the omission of signatures of certain arbitrators must be given. And the award may only be nullified if the concerned party successfully proves that the reason for the omission of signatures is needed is the absence of the of enough deliberation. An arbitral award must be reasoned as well. In other words, the award must set forth the basic reasoning of the arbitral panel on the main issues or the central issues raised during the arbitration process. The award must also include an operative part containing the decision. The award must have a maximum time limit to be issued according to the EAA of 12 months from the date of initiating the arbitration. Because the three jurisdictions have adopted the same model law, if we go through the slide again, we see that in different articles, the Egyptian, the KSA, and the UAE jurisdictions or arbitration laws have adopted the same requirements in general, which I just stated. With the simple distinction or difference is made for the UAE, which tried to expedite or to limit the time for issuing the award only for 6 months, and not to keep it like the other two jurisdictions for 12-month extension. And such period could be extended by, as just Sergey just mentioned, could be extended for another 6 months by decision of the arbitral tribunal. Now, going to the competent authority, what is the competent authority that would have jurisdiction to enforce the award in each of the jurisdictions in question? In Egypt, the competent authority to enforce the awards depends on the category, or if I may say, the nature of the award. In other terms, the Egyptian arbitration law has differentiated between two categories of awards that were the first category is the awards that were governed by the Egyptian Arbitration Act, thus having their seat of arbitration in Egypt, and the enforcement, on the other hand, the enforcement of the international commercial awards. According to the Articles 9 and 56 of the Egyptian Arbitration Act, jurisdiction over the enforcement of domestic awards to which the Egyptian Arbitration Act is applicable lies with the president of the court that was initially or originally competent to adjudicate the dispute had there not been an arbitration agreement. While jurisdiction over the enforcement of international and foreign commercial awards lies with the president of the Cairo Court of Appeal or any other court of appeal agreed by the parties. The competent judge in this case does not have the jurisdiction to review the judgment in substance. He either affirms or rejects the order. He either confirms the execution or enforcement of the award, or he just rejects it. He has no right to review it as a matter of law or fact, or to assess its content, nor the process of decision making involved in rendering it. Proceeding forward to the KSA, Saudi Arabia has acceded to the New York Convention in 1994. Unfortunately, the accession did not provide any relief to the level of uncertainty surrounding the recognition and enforcement of arbitral awards in KSA. In short, arbitral awards and all relevant documents still had to be translated in Arabic language, and submitted to the Board of Grievances. The board would then perform a comprehensive review of the merits of the case to ensure its compliance, the compliance of the award with the Sharia law. Additionally, the arbitration law of 2012 and the enforcement law promulgated as well in the year 2012 in KSA paved the way for the arbitration proceedings in the kingdom, ensuring that the process is as expeditious and effective as possible. In fact, in most cases, an execution order will be issued by the enforcement judge within a month of the application, showcasing the commitment of the kingdom to the expedited and swift proceedings. KSA arbitration law was supplemented by the enforcement law. One of the highlights of the enforcement law was the establishment of specialized enforcement courts within the kingdom. These specialized enforcement courts had exclusive jurisdiction in dealing with both domestic and foreign judgments and arbitral awards, and the judge responsible for the enforcement was tasked hearing any retrials if needed. According to enforcement law, the authority of the enforcement judge is final, without the scope of provision of any appeal. In the event that the debtor of the award in Saudi Arabia fails to pay the amount that is due or disclose any property in order to fulfill the conditions of the award within 5 days from the date of notification of the execution order, the Articles 46 and 47 of the enforcement law gives the enforcement judge to issue certain sanctions. Such sanctions, giving an example of those sanctions, is starting by imposing a travel ban on the debtor, and in extreme measures, even taking an order of imprisonment of the debtor, suspending the debtor's ability to execute or to issue power of attorneys, freezing the debtor's bank accounts and any other financial activity, order for the disclosure of the debtor's assets, order for the disclosure of the records concerning the commercial and professional activity of the debtor. Moving forward to the UAE, it is critical to recognize the difference between 3 different jurisdictions in the UAE related to the enforcement of the arbitral awards. It's critical to recognize that there are 3 major jurisdictions. The arbitration in the UAE is primarily governed onshore. It's primarily governed by the federal law number 6 of the year 2018 on arbitration, while the DIFC in Dubai, which is considered as an offshore jurisdiction, has its own arbitration law as well, also based on the unilateral model law. Arbitration seated in the DIFC is subject to the procedural framework set out in the DIFC arbitration law of 2018. In parallel, we have in the UAE the ADGM in Abu Dhabi, which is also considered as an offshore jurisdiction, having its own arbitration regulations, which were promulgated in the year 2015, and also modeled on basis of model law, the UNICITRA. Article 55 of the UAE arbitration law mandates that enforcement application for a domestic award, as onshore award, to be made before the Chief Justice of the competent court of appeal, or any one that he delegates from his court, who then will serve it to the respondent. The respondent can challenge the award with a set-aside action, as Sergey is going to elaborate at a later stage proceeding forward. The set-aside action could be filed within 30 days from the date of when the award is served, or when opposing the petition to confirm the award. As for the offshore UAE jurisdictions, which are the DIFC and ADGM, as I mentioned, an arbitral award, irrespective of the state or jurisdiction in which it was made, shall be recognized as binding within the DIFC, and upon application in writing to the DIFC court, shall be enforced. While in the ADGM, similar to the rules applied in the DIFC, the enforcement of the arbitral awards within the ADGM is applied on arbitral awards made in arbitrations where the seat of the arbitrations is in Abu Dhabi Global Market, or issued based on the New York Convention or the New York Convention awards, and all other arbitral awards which are sought to be recognized and enforced in the Abu Dhabi Global Market, irrespective of the state or jurisdiction in which they were issued or they were made. It is completely left to the discretion of the ADGM courts or the authority to recognize or enforce an award. Now, we will, on another note, I will mention to you what are the initial or the most important document to be submitted for enforcement. I'm going to go through them in a swift way because I need to give the platform to Sergey. Well, the original award or a certified copy of the award is a primarily necessary document to be submitted in the 3 jurisdictions, a copy of the arbitration agreement as well, a translation into official language, which is in our case the Arabic language, and a proof of depositing the award before the court. As you can see, due to the harmonization efforts that facilitated the unification, let's say, but under the unilateral model law, which countries adopted as state of art again for their national laws, the general formal requirements that are regarding the document list for recognition and enforcement of arbitral awards in the 3 jurisdictions are quite similar. Now, I would like to thank you, and I would like to invite back Sergey to this platform, who will be shedding light on the matters and issues related to challenging the arbitral awards in the respective countries of our study. Sergey?
Thank you, Fadi. Now we'll touch upon challenging arbitral awards under the Untitled Chapter law and under the laws of arbitration laws of Egypt, Saudi Arabia, and the UAE. The grounds are the same, and the only way to challenge an arbitral award under those arbitration laws is to apply to set it aside. The grounds under the model law, as we've seen in the introduction, are limited, and they are clearly set out in each of the arbitration laws. With Egyptian arbitration law, it's Article 53. With Saudi arbitration law, it is Article 50. With UAE arbitration law, this is also Article 53. There are 8 grounds available for parties to use in order to apply to set aside an arbitral award, and there's also discretion for the domestic courts to set the award aside on their own initiative, which is visible at the lower end of your screen, the last line. The court will be able to set aside an award on its own initiative if it considers or declares the award, the dispute not be able to be settled by arbitration, so not arbitrable, or if it considers that the award is in conflict with the public order or morality of the UAE. As you can see, all the grounds which we've provided here on the left-hand side, we're taking from Article 53 of the UAE arbitration law. Now, quickly going through each of those grounds, the first ground is perhaps the most crucial ground. There was no arbitration agreement between the parties, or it is now void, or it has lapsed due to a limited period of time when it was enforceable and available. Now, the other ground is incapacity of the party entering into an arbitration agreement, which is the second ground. This typically means that the person entering into the agreement was underage or had a mental issue which prevented him or her understanding of what they are entering into. Number three is the never-ending argument on legal, at least in the UAE, the never-ending argument on legal capacity of the party, of the individual that enters into an arbitration agreement on behalf of a corporate entity, and what type of capacity that individual is required to have under UAE law. On one side, the argument is that the individual has to have requisite legal authority, which would mean that their authority has to be clearly and expressly set out in writing in a formal document. For example, it may be the articles of association of a company, which would grant him or her such authority, or such authority may be expressed by virtue of issuing a power of attorney, again expressly setting out that particular power to enter into an arbitration agreement on behalf of the company. On the other spectrum, of course, the argument is that such individuals should have apparent legal authority to enter into an arbitration agreement. There, for example, if you are entering into an agreement with an individual sitting, for example, a manager sitting in a law office of a construction of a building development company, who issues a template agreement for that developer with developer's logo, for example, and that contract by default contains that arbitration clause, and there's nobody around telling you that this individual is unable to enter into arbitration agreements. You should be able to rely on representation of that individual, that he or she is validly able to sign the contract, which contains the arbitration clause, and that arbitration clause will be valid and enforceable vis-a-vis the corporate. The fourth ground would be lack of proper notice of arbitration, and this is where we, in the introduction, we're talking about ensuring that the party is aware that there is an arbitration ongoing, and trying to, as much as possible, invite and facilitate their appearance in the arbitration. Otherwise, it is a challenge based on lack of due process. Number five will be a situation where the award did not apply the law agreed by the parties, so the tribunal did not apply the law agreed by the parties, which is, of course, a crucial ground, because it just means that the parties' agreement and the parties' autonomy or ability to decide how they're going to run the arbitration and on what basis has been violated. Number six is composition of the tribunal was not in accordance with the parties' agreement. Similarly to the not applying the law which the parties agreed on, the parties also would agree on the number of arbitrators and the qualities and skill set of particular arbitrators, including, for example, their number, that they would have to resolve their dispute. If such an agreement has not been complied with, then again, this gives the debtor or the respondent an opportunity to, or even the claimant, the opportunity to try and seek to set aside this arbitral award. The award is marred by irregularities or not issued within the specific time frame. With specific time frame, again, we've highlighted in the beginning, you need to ensure that all of the time frames and periods and deadlines are respected. If not, it opens up your award to a challenge. Marred by irregularities is a specific wording from the UAE Arbitration Law, Article 53(1)(f) G, sorry, and it contains similar language in Egypt and Saudi Arabia Arbitration Law. The jury is still out on what exactly does this mean. There hasn't been much case law on, if any, on this particular point. And I think just time will tell what exactly, what is the bar for that ground to be usable vis-a-vis an arbitral award. In my mind, again, arguably, it may mean that the award contains so many minor issues that on their own will not be sufficient to set aside an arbitral award, but cumulatively, they just might breach that bar or that limit. And the eighth ground is that the award contains decisions which were outside the authority or the mandate of the arbitrators. The example I typically give is when the parties agreed in their arbitration agreement that the tribunal does have jurisdiction and authority to issue a decision on liability, but with respect to quantum, the parties would like a professional quantitative surveyor of some sort to calculate such liability and such damages. And if the tribunal goes beyond their limit and starts calculating and issues an award calculating such damages, then that particular part of the award, if it can be separated from the main award, and this is where it's important for tribunals and or sole arbitrators to ensure that each issue that they decide on has been separated out into a separate section within the award. Now, just moving on and quickly going through each of the individual jurisdictions, some of the aspects that I would like to highlight with respect to the Egyptian arbitration law. Article 52(1) clearly states that any challenges to arbitral awards can be done only in accordance with the Egyptian arbitration law and not in accordance to the Code of Civil and Commercial Procedures, the CCCP of Egypt. And this is helpful because before the situation was not particularly clear. Article 54 Egyptian arbitration law requires that an application to set aside an arbitral award must be brought within 90 days, which is 3 months from the date of notification of an arbitral award. And this is where we again go back to the introduction, where I've noted that you need to ensure that the arbitral award, you and the arbitration institution and the tribunal need to ensure that the notification has been made to the party. This is when the time period begins to tick, and the respondent party, for example, will have 3 months to apply for annulment of an arbitral award based on the limited grounds that we've just reviewed. Another helpful statement under Article 54(1) second sentence is that if during the conclusion of an arbitration agreement, for example, you've been pushed by a stronger party to sign an arbitration agreement which says that you will not be trying to apply for annulment of an arbitral award, such a statement is not binding, and you can still apply to set aside an arbitral award. Again, arguably, this is preventing the stronger party to impose its will on the weaker party, and just with respect to due process, you arguably should not be contracting out of your rights to make the wrong thing right. Article 54(2) provides which court will have jurisdiction in Egypt to resolve your application, and if the award has been set aside, then you will have a chance to appeal. But the initial court which will review your application will be the relevant court in Egypt, and for international commercial arbitration there is the Court of Appeal in Cairo. On the Saudi arbitration law, Article 48 clearly says that there's no appeal to arbitral awards. This is an important statement, again, considering the history of arbitration in Saudi Arabia and the Board of Grievances, which was, notwithstanding the fact that Saudi Arabia became a contracting party to the New York Convention, still continued the practice of de facto reviewing arbitral awards, including the substance of the dispute. So in 2008, an ICC award came out as an example with respect to a claim by a Saudi entity against MR in the UAE. The award was seated in the arbitration agreement, and the arbitration was seated in Riyadh. The award decided, the tribunal decided that the claim was not enforceable, so the claim was set aside, and MR was supposed to receive quite a substantial sum with respect to their legal fees because they were successful in the arbitration. However, the Board of Grievances, upon application to enforce, the Board of Grievances reviewed the whole award in a way that actually the claimant was awarded a sum of, I think, approximately 250 million dirhams vis-a-vis MR. So that was quite a shocking decision, which has now, by the Saudi arbitration law, has been rectified in a way. Not the decision, but the practice. Now, Article 51 of Saudi Arabian law provides a limit of 60 days instead of the 90 days which is allowed in Egypt to apply to set aside an arbitral award. And again, a similar statement that clearly says, even if you agree that you're not going to, if you waive your right to nullify an arbitral award, this is not binding, and you can still pursue a set-aside action. Now, Article 54 of UAE arbitration law has a number of good provisions on different aspects of set-aside and enforcement. So it clearly states under subsection 1 that the decision of the court whether or not to recognize the award and enforce can be appealed, and it can go up to the cassation level. In the UAE, the competent court is the Court of Appeal of each of the emirate. Set-aside action now is barred to 30 days instead of Egypt's 90 days and instead of Saudi's 60 days. Now, in the UAE, you need to be very careful because you have only 30 days to apply for a set aside. Therefore, if as soon as you receive the award, you're notified of the award, the time starts ticking. It is the day after you receive, the timing starts the day after you receive the award, and it's clear 30 days. So you need to act quickly if you're planning to set aside an action. So you need to review the award, you need to consult your legal practitioner, and decide on when, whether you're going to be able to do it within 30 days, and you typically should. A decision to set aside an arbitral award shall extinguish an award in whole and in part, which is subsection 3. It just gives the opportunity for a court, if they're going to set aside a certain section of the award, that the main award or the parts which are valid and enforceable are kept enforceable. The subsection 4 is very important, considering some of the UAE judgments, which requires that the agreement will remain in force, notwithstanding the fact that the award was set aside. So, for example, if the award is set aside for reasons that the other party was not formally notified of the arbitral proceedings, subsection 4 says that in that case, the agreement still remains in force, and you can reinitiate arbitral proceedings. The other question is whether you're going to be willing and able to spend another 12 to 18 months in arbitration and pay another advance on costs. But that's, of course, one of the considerations to be had. And the award remains in force unless the set aside of the award was based on the fact that the agreement simply does not exist, which is, of course, the fundamental requirement for any arbitration, the existence of an arbitration agreement. Again, number 5 is similar statement that even if you waived your ability to apply for set aside in the contract, for example, this is not binding and you can still do it. Number 6 gives a court an opportunity to fix an award, or the tribunal an opportunity to fix an award. For example, in a recent case that we had, rightly or wrongly, the Court of Cassation decided that it is a requirement that the award is signed on each and every page still is in existence, and it should be signed on each and every page. So the court has given, under Article 54.6, the other side an opportunity to get the award signed by the arbitrators within that period of time, in order to save the award, again, because the formalities were not complied with according to the Cassation Court, and the court was kind enough to grant this opportunity to fix the award with respect to all the formalities. Now, one of the issues to consider is if you're trying to enforce an award and the other party is at the same time challenging it, is it necessary to stay your enforcement efforts? No, it's not. At this stage, under all of the arbitration laws, Egypt, Saudi, and UAE, you can still proceed with enforcing, with your enforcing efforts, and it's a clear statement under each of the provisions that the enforcement efforts will not be stayed. Nevertheless, the court has discretion with respect to staying the enforcement process if there are serious grounds or a good cause to do so. For example, the other side with their challenge application has to an extent demonstrated that they have a very good basis for their challenge. However, in these circumstances, if the court stays the enforcement of an award, there will be a limited time granted to the court to decide on the challenge or the set-aside application. And in Egypt, it will be 6 months. In Saudi Arabia, it will be also 6 months, but in the UAE, this is 60 days, so 2 months that the court will have to decide on the challenge. Now, with conclusion, and I see that we are running out of time, unfortunately, the conclusion is a couple of tips that we would like to offer you, which are on the screen here. Based on what we've discussed today, you're advised to spend a little to save a lot. Again, consider enforcement and challenges in the beginning of your arbitration, and better even in when concluding an arbitration agreement. It will certainly save you time at the other end of the arbitration process. Don't cut corners during the arbitration. Make sure that everything has been complied with that is necessary. If the tribunal even sometimes pushes the process and tries to expedite it a little bit, just double check and see how it will be viewed at the time of enforcement of proceedings. Again, another circumstance to be aware of is where are you with respect to that award, and what position? Do you have enough? Are you willing to spend more time on enforcing? How much does it cost you? Are there alternative options to pressure the debtor into paying according to the award? Is there any point of chasing the debtor? Maybe the company is, again, it's a shell company which has no assets, and you should definitely keep that in mind. And of course, knowing is half of the battle, which hopefully we provided you with some good basis for starting your enforcement or challenge efforts vis-a-vis an arbitral award. And it's crucial with enforcing and challenging an arbitral award to know all the requirements, all the limits, and differentiate between different jurisdictions. One of the highlights that we would like to leave you with is that whilst all of the Saudi, Egyptian, and the UAE arbitration laws are relatively similar, because all of them are inspired by the model law template, there are certainly differences that you must be aware of, and including the differing time limits. I think at this stage we will potentially try to answer some questions, but I think we may have run out of time.
Thank you, Fadi and Sergey, for your practical insight on the crucial topic. Regarding the questions, I'm sure we can address it later if that works for the both of you.
Yes, we'll be happy to write to each of the individuals who has put their questions in and answer them.
Okay, that sounds great. And if the delegates have any further questions, please do reach out to them, or you can send us your queries as well, and we would be happy to forward it. Our sincere thanks to the firm Galadari Advocates and Legal Consultants for leading the discussion. To the extended team at the firm, thank you for your help in organizing the session. We would also like to thank our legal research partner, LexisNexis, for their support. And of course, to my colleagues at Niche Publishers for your support as well this morning. A recording of this webinar will be available on the Oath Magazine's website. Thank you for joining us again this morning. I wish you good health and a wonderful week. God bless. Thank you, Sergey and Fadi. Thank you so much.
Thank you, Ruthie. Goodbye, everyone.